We are here on a motion order to show cause in this matter. And let's see, also a motion for default is my understanding as well. And it's my understanding that the parties have reached an agreement regarding this matter and wish to place that agreement on the record. Is that correct?
Yes, Your Honor.
All right, who is going to do the honors?
I can do it.
All right.
All right, thank you, Your Honor. So, Your Honor, the agreement today is going to be for.
Welcome back, everyone. Today's case dives straight into the heart of custody negotiations, high-stakes parenting disputes, and a courtroom trying to balance fairness with urgency. Right at the start, we have a motion to show cause, a potential default ruling, and, get this, a last-minute agreement between the parties that could reshape the entire outcome. You're going to see discussions about parenting schedules, supervised versus unsupervised time, housing requirements, and even restrictions around relatives' homes. This case has layers, emotion, and strategic negotiation from both sides. Pay close attention because every term they place on the record affects the long-term future of 3 children. And trust me, some of these conditions spark major questions. Let's get into it.
Custody and for the parenting time schedule. We would then resolve all of the pending motions. The issues of child support, spousal support, and property division would be reserved. They're not before the court today anyway. And we would, these custody and parenting time terms would be the final order. It's the intention of the parties that these would be the custodial and parenting time terms that are in the judgment of divorce. Right. With respect to custody, the parties would be awarded joint legal custody.
Okay, pause here, because this early portion of the agreement tells us a lot. Both parties are locking in joint legal custody, meaning major decisions, education, healthcare, religion, must be made together. But physical custody? That's going solely to the mother, which gives her primary control over the children's day-to-day life. This is a big distinction, and courts do not hand out these splits lightly. The father still gets structured parenting time, but notice how detailed the schedule is. School year pickups, snow day contingencies, summer adjustments. When a court order drills down this specifically, it usually means past conflict required a tightly managed framework. What do you think? Does this arrangement seem fair so far, or is one parent giving up more than expected?
With respect to physical custody, sole physical custody would be awarded to plaintiff mother. As for parenting time, we'd have a year-round schedule. The year-round schedule would consist of defendant father exercising parenting time each Wednesday. During the school year, that would be picking up after school or 3 p.m. if school were canceled for a snow day or something. He would pick up from plaintiff mother at 3 p.m. During the summer, those Wednesdays would be picking up at 5 p.m. He would return the children to plaintiff mother at 8 p.m. on those Wednesdays. So those are non-overnight evenings. He'd also exercise parenting time year-round on an every other weekend schedule, picking the children up from school on Fridays. If there is no school, again, for a snow day or some reason like that, and during the summer when there is no school, he would pick the children up from a plaintiff mother at noon. And then he would drop the children off during the school year on Monday mornings at their school. If there's no school, again, because it's summer or school is closed, he would drop them off to plaintiff mother at 9 a.m. Parenting time is currently supervised. With this agreement, we would lift supervision, and his parenting time would go to unsupervised parenting time. But presently, his living situation is in flux, and so those overnights will not begin until he has stable housing that is safe and appropriate for the number and the gender of the children. Defense counsel and I have discussed the fact that once the judgment of divorce is entered, there'd be no prohibition placed on defendant father as to other appropriate adults who he might enter into a relationship with. You know, we're not trying to prevent that long term. But he would not be residing with the children in his brother's home. There would be no contact with the home of his mother, Sandy. It's not a no contact on the individuals, but it is a no contact on his mother's home. And I think the parties understand what that means. So until he's able to get that safe, stable, and appropriate housing, his every other weekend parenting time would just be Saturdays during the day and Sundays during the day, starting at 9 a.m. and ending at 6 p.m. There just would be no overnights until he's able to establish that housing. In addition, the parties will work together. Should either party wish to take a child to an event during the week. So if defendant father wants to take the child to a sporting event or vice versa, they will try to work that out. They'll try to be accommodated to one another on those types of issues. Both parties will have 2 weeks of 7-day non-consecutive extended vacation time to exercise in the summer months. It would be inclusive of their already scheduled weekend, and they would have to provide 30 days notice of the dates that they intend to exercise that. In the event, and defense counsel and I didn't discuss this, but I think it's customary and I don't think there'd be a disagreement. I think we would include language that if there is a dispute about dates because they each want to take time that conflicts, we would alternate who has first priority on an every other year basis to resolve those disputes. But I don't anticipate that there's going to be many disputes since it has to be inclusive of their already alternating weekend. So I think we'll be fine there. In addition to that, there will be a holiday default schedule, but the way the provision will be drafted is that the parties will exercise holidays as they agree. And so we want to give the flexibility to the parties to decide what works best for the holidays for the children. But in the event that they can't agree, then we will be adopting the schedule that's found in the Ottawa County Front of the Court model.
This section is incredibly important and shows how complex co-parenting cases can become. The court isn't just ordering a holiday schedule, they're building in a default safety net in case the parents can't agree. And the fact that they're referencing the Ottawa County Model Plan tells us they want zero ambiguity because holiday disagreements are one of the top triggers for post-divorce litigation. Also notice the detail about extracurriculars. These kids, 7, 9, and early teens, have busy schedules and both parents must support that. Courts love to see this. It shows consistency and stability. But here's the big question for you. With the father's housing still unstable and supervision only recently lifted, do you think this flexible holiday plan will hold up smoothly, or are we looking at future disputes? Comment your thoughts.
Plan as it currently exists today. Defense counsel and I will put that schedule right into the order and then ultimately the judgment of divorce so that there's no disagreement. And I know from time to time that plan changes and there's changes for different age kids and it can be a little bit of a mess if it's not memorialized. So we will actually put that schedule right into the judgment of divorce. The parties will also be responsible for the children attending their extracurricular activities that fall from time to time during their parenting time. We're talking about a 7-year-old, a 9-year-old, and a 14-year-old, 13-year-old. These are busy children. And there's a lot of things that they go to. It's our understanding that the parties agree that their kids are able to continue to participate in that. And so both parties will be responsible for making sure they attend those extracurriculars. We will include Hague Convention language. We will include the other statutory provisions regarding domicile and residence and the other customary language that we would see in a judgment of divorce related to custody and parenting time. I'll prepare the stipulated order and we'll go ahead and provide that to the court to enter that stipulated order. But it is the party's intention that these terms would be merged and incorporated to the final judgment of divorce. That would resolve all pending motions that are before the court. And I believe, and one other agreement that will be in the plan is that should defendant father decide to come back to the court at some point after the judgment of divorce is entered and seek an expansion of his summer parenting time, so this would only relate to the summer parenting time, there would be a stipulation that it would be the shade standard. That would be the threshold for defendant father to meet. I believe that's the totality of the agreement.
Mr. Barnett?
Judge, we were in agreement also that, we're not agreeing on child support calculations right now, but when that calculation occurs, we agree to use 125 overnights for, Mr. McHenry.
That's
Mr.
correct.
Worth?
That is correct.
All right.
And I would just want to make one clarification. The no contact doesn't have to do with the brother's home, only the mother's home, Rodney's mother's home. But Mr. Opposing counsel is correct that there is no overnights at the brother's home. Is that correct?
That's right.
And then finally, my last thing is, and this was just because this went in there about the choice going back and forth. I would ask that Rodney get the first choice every year because of his limited parenting time. But of course, if there's something special that Sydney is like, oh, hey, this is going on and we'd like this, Rodney will work with Sydney to make sure the children can.
This is the danger of trying to solve a problem on the fly as it comes up. We, from just kind of a fairness standpoint, we'd like to see it alternate. At the same time, I hate to take an otherwise appropriate agreement and light it on fire. It seems to me that for both parents, the probability of conflict is extremely low, given that they have to exercise that time inclusive of their ordinary weekend schedule anyway, which again cuts both ways, but we would like to alternate it. Judge, I don't know if you feel it's appropriate for you to weigh in on a perspective here.
I think unless you have an agreement on it, that you need to eliminate that provision.
Let's do this. Let's agree on alternating it, but let's have language in there that says if either party has something that comes up that's special to that year, both parties will work with the other to make that request happen.
Yeah, we're okay with that. And I think the parties would do that. That's fine.
And then my last thing, just because I don't want to be filing an ex parte on this in a few minutes. I think the intent of this order is to take effect immediately. I just want to make sure Rodney's going to be able to have parenting time on Wednesday.
Yes.
Okay.
We'll give it immediate effect.
All right. All right. Do you wish to inquire of your clients?
Yes.
All right.
All right. Do you want to swear or?
I can, if that's what you'd like. Would you raise your right hand? Would you state your name and spell it for the record?
Sydney McHenry, SYDNEY MCKENDRY.
And do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Worth.
All right. Mrs. McKendry, you've heard the terms of agreement as they relate to custody and parenting time that were placed on the record this morning, correct?
Correct.
And you understand those terms?
Yes.
All right. And have you had an opportunity to ask me about what those terms mean, both legally and what it might look like to be bound by those terms?
Yes.
All right. And we've discussed the fact that if you had a trial on these issues, you could get a worse result, a better result, or the same result.
Yes.
All right. And that by agreeing to be bound by the terms of this settlement on the record this morning, you are not going to have a trial on the issues of custody and parenting time. You understand that?
Yes.
The other issues, child support, spousal support, and property distribution have been reserved, and those are not impacted by the agreement this morning other than the 125 overnight provision. You understand that? All right. Is it your intention to be bound by the terms that we've placed on the record this morning as to custody and parenting time?
Yes.
And do you believe that overall, considering the actual parenting time and custody terms, as well as resolving the stress that comes from litigating the matters impacting the children, that these terms will be in the best interest of the children?
Yes.
I have no other questions.
Thank you. Mr. Barnett? Would you like your client sworn?
Please.
Sir, would you raise your right hand? Would you state your name and spell it for the record?
Rodney McKendry, RODNEY, MC. KENDRY.
Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes, yes.
Thank you.
Thank you, Judge. Mr. McKendry, you and I have not had a long time to talk about this. I've only been on this for a week, but we have had several conversations within the last couple of weeks about this case.
Yes, yes,
We've talked about the parenting time provisions that were placed on the record today, yes?
yes,
You understand that you get joint legal custody, but physical custody goes to Sydney?
yes,
And do you agree that do you agree to be bound by the parenting terms that were placed on the record today?
yes,
You understand that you can petition the court at a later date and time should circumstances change that would allow you to do so?
yes,
Do you believe, as Mr. Worth stated, considering all the factors, the stress on children in litigation, the stress on the parties in litigation, that this is in the children's best interest to enter into this agreement?
yes.
Is there any questions you have about this agreement?
No.
That's all I have, Judge. Thank you.
All right, thank you. I'd like to congratulate the parties on what I believe is a reasonable settlement that's in the best interest of these children. It's always better for the parents to come up with a solution for their children as opposed to a stranger, myself, imposing that solution. I know neither one of you got everything you wanted, but that is part of the art of compromise. And sometimes that's what we have to do, again, in the best interest of children. So I congratulate the parties as well as counsel on coming up again with what I believe is a reasonable agreement. I'll find that it is in the best interest of these children. And who is going to prepare the order?
I will, Your Honor.
What a case. By the end of this hearing, we see the court fully affirming the agreement as being in the children's best interests, something judges never say lightly. Both parents acknowledged the terms, understood the risks of going to trial, and agreed to a structured plan that balances stability with the father's opportunity to expand parenting time in the future, provided he secures safe, appropriate housing. The 125 overnight stipulation for future child support calculations is also huge. That number directly impacts financial obligations. Overall, this is a textbook example of cooperation under pressure. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.